Item number 14, my lord.
Oh.
WPC 11175.
Hmm.
The petitioner got relief, my lord. So nothing remained, my lord.
You asked Jahan.
Yes, Jahan, yes.
Mr. S. Jahan and counsel for the petitioner submits that the matter has become infectious.
My lord.
Accordingly, district petition is disposed of as infectious.
Yes.
May it please your lordship.
Hmm.
Lordship, I beg to mention item number 10 of today's daily list.
Yes,
Lordship, we need some time to reconstruct the file. It's an old matter.
you are for it?
Respondent, Lordship.
I am
Health
put a
Department.
petition. I am put a petition. Malab.
Okay, you're good now?
S. Bodhakumar.
Yes,
Bottakul.
Bottakul and for the petition. On request made by Mr.
M. Huya, Lordship. On behalf of DP Bora, Lordship.
Okay, on request made on behalf, made on behalf of Mr. D.P. Bora. Then the Standing Council Health Department.
Health Department.
When do you want?
Lordship, 2 weeks will be enough.
It's after 2 weeks.
Much obliged.
Fix that, Malab. Fix that, Malab.
You want a date fix? 2 weeks. Okay. 12th March.
Much obliged, Lordship.
May I please? Lordship, I beg to mention for listing this matter for admission, Your Lordship. On 20th February, Your Lordship.
22nd.
Yes, Your Lord.
22nd.
Obliged.
May I praise your lordship? Lordship, I pray for listing of a matter tomorrow, lordship.
Why tomorrow?
Lordship, the issue here is, lordship, this is regarding a promotion from forest guard to forest guard grade 1.
Hmm.
Lordship, we were granted promotion, our promotion was cancelled. We came up before this honorable court. This honorable court by order dated 1st of February 2024 upheld their promotion. Now again, lordship, notice has been issued to us seeking written explanation as to why we should be granted promotion. Lordship, promotion has already been upheld by this honorable court. And that notice written reply we are supposed to file by tomorrow. Okay. For that. Much obliged.
Maybe I beg to mention listing admission matter, madam. Next week, any date, madam.
26.
26.
Yes.
Obliged.
May it please your lordship.
Hmm.
Also, with regard to item number 8, your lordship. Lordship, on 12th, we have filed an additional affidavit, lordship.
Hmm.
That may be brought on record, lordship. Today is for disposal, lordship. Actually, the petition is about to retire, your lordship. Hardly, okay, petition may be. Much obliged.
May it please your lordship.
Hmm.
I pray for listing of a contempt matter for orders, lordship. Any date next week.
26.
Much obliged, your lordship.
Lordship, I'm praying for listing of an admission. Can it be on 19, Lordship? Pen matter has become infractious.
Okay.
Obliged.
Lordship, item 1 of today's list.
Hmm.
The arguing counsel would not be present today.
Who is the council?
SP Sharma.
Okay, on request made on behalf of SP Shamal and the council for petitioner.
2 weeks. 2 weeks.
The matter after 2 weeks. Yes.
May it please your Lordship. Lordship, I beg to mention this case for listing. This matter is related to compassionate appointment. It will be listed on next week, Lordship. Any date?
28.
I beg to mention one item for Woodrow Lordship tomorrow.
Why tomorrow? Day after tomorrow. Saturday.
Saturday. Lordship, actually, Saturday I will be out of station because of his Lordship. I pray Lordship tomorrow if possible, Lordship. For Woodrow.
Okay.
Much obliged, Lordship.
Item 2 for motion. May I please, your lordship?
Hmm.
The petitioner, my lord, initially, my lord, pursuant to an advertisement, my lord had participated, my lord, in the office of the superintending engineer, my lord, Tezpur Mechanical, my lord, circle of the irrigation department, my lord. There were two posts of junior assistant vacant, my lord. Accordingly, my lord, the petitioner applied pursuant to the advertisement, my lord. And lordship will find it at page 34, my lord. 32, my lord. She, my lord, got 83 marks and was the highest, my lord, got the highest marks, my lord, in the written examination.
Hmm.
But that was, my lord, unilaterally reviewed by the authorities, and her marks were reduced to, my lord, 76. Accordingly, my lord, when the final list was prepared at page 35, my lord, she became, my lord, third, my lord, because of the reduction of the marks, my lord. And, my lord, the first and second person, my lord, who became, my lord, because of, my lord, that reduction, my lord, the first and second person, my lord, they were appointed, my lord, in 2014, my lord, at page 36.
Yes.
My lord, in the meanwhile, I had already filed a writ petition, my lord, In that writ petition, my lord, page 41, lordship will find, my lord, the government, my lord, while during the pendency of the writ petition, my lord, admitted their mistake. That yes, there was an error in my lord, review, my lord. Lordship will find page 41. Dr. Ahmed fairly submits that there were errors in assessing the written examination of the petitioner, which resulted in her securing lower marks. Steps are now being taken to review the marks awarded to the petitioner and rectify the error committed. Then, my lord, they, my lord, committed my lord, did a review, my lord. Then the review committee, page 43, my lord.
Yes.
My lord, they decided to appoint me now, my lord. With reference to the above, I have the honor to inform you that the review meeting of the selection committee was held in the office chamber of the undersigned on 26 2015 to review the marks obtained by the petitioner and written test, and decision was taken in the meeting to appoint the petitioner against the resultant vacancy under the establishment of the circle.
Mm.
Now, my lord, accordingly, my lord, I was appointed, my lord. That appointment letter, your lordship, will find it page 49. 2015, my lord. This is dated 3/8/2015, Annexure 12. In pursuance of the Chief Engineer Irrigation Assam Government Letter number so-and-so, in the interest of public service, the following candidate is appointed as a junior assistant temporarily and until further orders under the establishment of Tejpur Mechanical Circle Irrigation, Tejpur, against vacant post of so-and-so, so-and-so, and so-and-so, so-and-so. The appointment is purely temporary, so-and-so, so-and-so. No, accordingly, she joined, my lord. Writ petition was closed, my lord, and she joined, my lord. Now, the difficulty here is, my lord, that because of this, my lord, she is, my lord, has become junior to the persons, my lord, who were appointed prior to her, my lord, because of the mistake, my lord, committed by the authorities. Now, my lord, the next promotion is due, my lord, and my lord, she will be losing that also, my lord, in a sense, in terms of seniority, because 2 vacancies were there, my lord. 2 persons were appointed, my lord, depriving me, my lord. And though they were, my lord, lowly ranked, lower ranked, my lord, in the merit list, my lord. But I was not appointed because of the mistake committed by the authorities. They admitted their mistake, my lord, but appointed me in 2015 after them, my lord. Accordingly, I have lost my seniority, my lord. Now, the next promotion is due, my lord, and now I will be in a position where I have already lost, my lord, more than, my lord, few years of service, my lord, because I was appointed in 2015. So 1 year of service I had lost earlier, my lord. For that purpose, for that period, I did not get any salary and anything, my lord. Now, my lord, I will be losing the seniority also, my lord, because of the anomaly which occurred at the time of my appointment, my lord. And it's an admitted position, they committed the mistake, my lord. So therefore, my lord, can I be deprived, my lord? That is the issue, my lord. Can I be deprived of that, my lord? Therefore, my lord, my prayer is, my lord, that I should be given, my lord, at least seniority. My seniority should record, my lord, from the date, at least, my lord, from where the other persons were appointed, my lord. Ahead of me, my lord, though they were in a lower rank in the merit list. That is the case, sir.
Yes.
My lord, last you directed me to
No.
The instruction whether any promotion has been going to be done or not. My lord, there is no move in scope, my lord.
There's no move
No move
till now.
till now, my lord. No move. There is no move.
Then we'll issue notice.
Well, in fact, I had also, my lord, submitted representation, my lord. My lord, they say that lordship will issue notice, my lord. They say, my lord, that I'll be entitled to salary and other benefits from the date of joining in service. So they have basically denied, my lord, that I'll not be getting that
My lord,
other.
there is no such order. That my lord, his service may be retrospective, my lord. And
Here, the issue is when you corrected the marks,
yes, my lord.
because of that correction, petitioner came down to 3rd position.
Yes, my lord.
Okay. If you have not corrected that marks, petitioner should have been in the 1st position and he or she would have got the appointment.
He
Correct.
admitted, my lord, but
So you admitted that mistake,
my lord.
you corrected that mistake,
Mhm.
then you appointed her.
yes, my lord. But now,
Now-
if he is appointed, his seniority is given from the date of the earlier incumbent appointment, my lord, he will come for such salary, my lord, area
No,
salary.
no,
my
no,
lord.
that the court will make it very clear that it will be only for the purpose of seniority.
Yes, my lord. Notice may be issued, your lord.
Hmm?
Notice may be.
Okay, it's actually, any private respondents are there?
No,
Yes, my
private
lord.
respect. This is
There are two private respondents.
6 and 7. They are there, my lord, but then
Then notice.
because I'm claiming seniority over them, my lord, they have
Notice
to
is
make part.
required.
Yes, notice it.
Heard Mr. M. Datta.
My lord.
Then it comes. Issue notice. You are
I'm
paying
preparing for irrigation department, my lord.
MS.
DS new correspondent number 11345.
Starting council, irrigation department, affairs correspondence.
1345.
1, 3, 4, 5. Finance? P. Nayak? Mr. P. Nayak, Leonard, standing counsel.
Mr. B. Gogol. P. Nayak is out of station, madam. Mr. B. Gogol, nothing.
B. Gogol.
B. Gogol, not.
Mr. B. Gogol, Leonard, standing counsel. Finance appears for the response number 2. Stop.
Okay.
Extra copies will furnish to the legal counsel for the respondents. Petitioner to take steps for service of notice on respondents 6 and 7 by registered post daily. Within the period of 1 week,
My lord.
list the matter. Respondents are allowed to file all draft documents. List to 4 weeks.
In the meantime, no promotion may be
No,
the leave of the
There
court.
is
my
no
lord.
She has
subject
made
matter.
it clear.
My lord.
Leonard, in the last para, Leonard standing counsel submits that presently there's no move to fill up the post of assistant, senior assistant in the irrigation department. And as such, no stay order is being passed at this stage.
Well, I will be given liberty to approach my lord at appropriate
Yeah,
time.
that you can have. your-
Deeply obliged.
Well, there's a mistake, my lord. The respond number 6 in the my lord, tabulation and my lord, the serial number respond 6 7. There's a mistake, my lord. I'll be allowed to correct it. Which paragraph? Oh, my lord. In my lord, in the cost item page 6, my lord. Actually, respond number 6 ought to have been respond number 7, my lord. There's a mistake.
Respondent 6?
Respond number 6 ought to have been respond number 7. Actually, my lord, there's a mistake, my lord. Well, let it remain that way, my lord. Let's not make a difference.
Don't make a difference.
Yes.
Item 3 for admission.
Seek some accommodation in this case for today, Lordship. Can it be taken up on the 5th or 7th of March, Lordship?
Yeah?
I'm for the petitioner, Lordship. M. Das.
When do you want?
Lordship, 5th or 7th of March, Lordship.
5th March, not. There is an interim order there. Lordship. I have, there's an urgency there.
Made by Mr. M. Das, and counsel for the petition. List the matter on 5th March.
Obliged, Lordship.
I was waiting for response number 7, Lord.
Ms. Arbor, Leonard counsel appears for the response number 7.
And Mr. D. Gogol is not saying we recorded for response number 8 and 9.
He's absent.
My lord, he's in another court, my lord.
Can
Apart from that,
be Google and standing counsel,
Caution of standing also for private response.
Leonard counsel appears for the respondents
8 and 9, Lord.
8 and 9. Okay.
Item 4.
May I please, your lordship?
Yes,
Your lordship, I pray for a short passover as my senior counsel is on his way to the court.
Or my lord can fix it next week also, my lord. There's no problem because the connected contempt petition has not come today before your lordship. Even that will be necessary.
okay.
Your lordship can have it on 22nd, my lord.
Heard A.K. Borrell and counsel for the petitioner. On request made on behalf of Mr.
J. Rahman, J. Rahman,
No, you have
on behalf of PJ Pukan.
PG Fukan and a standing counsel, Guwahati University.
Yes,
Please
your lord.
count. When do you want?
22nd, my lord.
Okay.
Well, along with my lord, a contempt case number, my lord, 423 of 2022, my lord.
Along with contempt case number
423 of 2022, my lord.
422.
Obliged.
Highly obliged, your lord.
Deeply.
Item 5.
But this was otherwise to be taken up for admission hearing today.
Hmm.
Issue involved, my lord, is dismissal from service for contracting plural marriage, my lord.
Contracting?
Plural marriage, my lord.
Okay.
During the subsistence of the first marriage, though there was, my lord, no formal divorce, in fact, the wife had actually deserted him. So he contracted the second marriage, and the authorities, my lord, charged him with the charge of plural marriage and dismissed him from service, my lord. But then the law, more or less, in this regard, is that dismissal from service in such circumstances, my lord, is a harsh punishment. So in most cases, my lord, either compulsory retirement or other punishments have been awarded, which then entitles him at least to the pensionary benefits, my lord.
Where's
And
the
so
other?
GSC, my lord, R. Devi, my lord, she was there. Can we have it next week, my lord? The issue is like very simple
But
otherwise.
Mr. P. Pathak, learner counsel for the petitioner. None appears for the respondents. When do you want?
But it can be on next Thursday, my lord,
22nd?
22nd, my lord.
It's on 22nd.
Deeply honored.
Item 6.
May I please, Lordship, kindly pass over that.
For the day.
My Lord, sir, legs on another court.
Who's your counsel? Who's your senior?
H.R. Chaudhary.
Okay.
7.
Please, dear Lordship, I am for the veterinary department. Lordship, I am be allowed for 2 weeks. I may be allowed to file my affidavit, Lordship.
Where's the petitioner's counsel? Okay, none appears for the petitioner.
I'm for 1, 3, and 5, Lordship.
MS, MM,
Kotoke.
M Katoki or MM?
Kotoke.
MS, MM Kotaki. Then a standing council, animal husbandry and veterinary department. Is allowed how much time?
2 weeks time now.
2 weeks time to file contract, David.
I appear for response when government.
List after 4 weeks, or list after 2 weeks. Mr.
D border.
D. Bora, then government advocate appears for respondents.
2 and 2.
2 and 4.
Of like,
Pray for time being, your lordship, because the additional report is not yet received, your lordship.
Not
Maybe
yet come.
not yet, your lordship, after some time, lordship.
Item 15 and 16 from supplementary list.
The other day, the advocate of the APDCL disclosed to your lordship that they will submit the report that they are considering our case. I don't like today, my friend is still not yet come. My lord, here we have prayed in both the cases that we should get a direct payment. Nowadays, payments are being paid through the accounts of the other employee. All are outsourced employee, my lord.
Yeah, where's the APDCL council?
He has not yet come. Let it come a little later. I think he will come.
Item 9 for orders.
May please, your lordship.
Yeah.
My lord, here in this case, my lord, petitioner was allowed to take a substitute mode of service by paper publication. That we have taken, my lord, and we have also filed an additional affidavit enclosing the paper publication. My lord. So, my lord, now the
Anybody appearing?
Lordship, we
Where's your affidavit?
my lord, we have filed, my lord, on 29th of January. Enclosing the paper publication made in vernacular newspaper Osomia Pratidin and Assam Tribune as directed by this honorable.
Where's the other one?
My lord, others steps has been my lord, service has been completed. Only, my lord, respond number 9, 12, 16, 19, 20.
1 minute. Yeah.
On instruction, I will file my wakalatnama by tomorrow itself for respondent number 31 after getting this notice.
Okay, 31.
Yes.
You on time?
Lordship?
You on time?
Yes, tomorrow it is coming on transit. I'll
Okay,
file that
heard
tomorrow.
Mr. Shipta, then the counsel for the petition. Stop. Para. There is the affidavit, additional affidavit filed by the petitioner showing substitute service on the respondents 9,
9, 12, 16, 19. Para 3 has been, we have stated, madam.
9, 12, 16, 19, 20, 22.
9, 12, 16. You just check up this page 318.
Yes.
Here the serial is there. Okay. Which was published in 2 newspapers. One in Assam Tribune and the other in,
Asamiya Pratidin, man.
you know, stop. On perusal of the same comma, the notice on the aforesaid respondents shall be deemed to be complete. Stop. Para. MS
S. Dasgupta,
S. Das Gupta, Learned Counsel, enters appearance on behalf of respondent number 31
31.
and prays for some time to file Vaklatnama. Stop. Praise allowed. List the matter for admission after 2 weeks.
Well.
After 2 weeks.
Much obliged.
Deep lovely.
And I have missed the train, my lord. Item number 7, Lordship has passed the order.
Mm.
15 days, only date may be taken.
What did I say? Item 7.
The opposite party took the time for 2 weeks for filing affidavit.
Okay.
Only that.
Don't say none appears, say heard. PG3 Learned Counsel for petitioner. And then MSO and so on. List on after 2 weeks, he said. Okay. Okay. 11th March.
Obliged.
Item 17 from supplementary list.
May I please, your lord.
Mm.
My lord, as per ultima order, my lord, service upon the response number 8 is answer, my lord. Otherwise, the in the remaining respondents, the service is completed, my lord.
Mhm.
And as per the, my lord, order dated 19/9/2023, my lord. This the other 2 matters has to be supposed to be take with this matter, my lord. Similar matter, my lord. The same petitioners and same respondents, my lord. Only, my lord, there are subsequent developments, my lord, in the other petition. Order dated 19/9/2023.
Who's the respondent number 3?
My lord, respond number 8, my lord.
No.
My lord.
3.
3, my lord. State respondent, my lord. It's
You're serving to the respondent number 3.
Three, my lord, is Inspector General of Police, my lord.
Anybody appearing?
No, sir, I am appearing for respondent 1, 2, 3, and 4, Lord.
Oh.
Official respondents. Lord.
Have you served the notice?
Take the notice, Lordship. Respondent 1, 2, 3, and 4, Lordship. I received that copy, Lordship.
No, yes, they're supposed to make service of notice on the respondents 5 to 78.
But they are private respondents, Lordship.
They are private respondents, my lord.
Through the respondent number 3.
Yes, my lord, that is, we have prayed in, my lord. But separately, you have taken the steps also on the private respondents. my lord.
Okay, separately.
Separately, you have taken steps.
What about 29?
My lord, on the remaining respondents, my lord, through respondent number 3, we can serve the notice, my lord. As we have already stated, my lord.
1 minute.
It has been not served, Lordship. As per the respondent number 3 is concerned, Lordship. Copy has not served, Lord.
My lord, we have taken individually, my lord, steps upon the, my lord, on the remaining, my lord.
1 minute, 1 minute.
My lord. Separately. Individually. ঠিক আছে। যোন কেইজন থাকি যায় সেইজনৰ ওপৰত দি দিম।
Okay, heard, Mr.
Well, as Hazarika, ma'am.
Yes, Hazarika, let me counsel for the petition. Stop. Produce the order dated 13/2/2024 of the Lawazima Court. Stop. The notice on respondents 5 to 78. Except respondent number 8 shall be deemed to be complete. Stop. Para. 8, what do you want to do?
Well, we can serve through Inspector General of Police, through respondent number 3, madam.
The petitioner is permitted to serve notice upon the respondent number 8 through the respondent number 3 by registered post AD.
My lord,
By registered post AD within 1 week,
my lord,
1 week from today. List after 4 weeks.
my lord, as per the order date 19/9/2023, my lord, the other two matters are pending, my lord. Similar, my lord, WPC 5482 and 3835. My lord, kindly peruse the order date 19/9/2023. Paragraph 13, my lord, of that order. Similar, my lord.
List the matter after 4 weeks. Along with WBC number 5482 of
My lord.
2021 and WBC number 3835 of 2023.
In the meantime, my lord, the respondent can file their affidavit, my lord. The matter, my lord, yes, my lord, it is 3 times, my lord. There is a third round of my lord.
In the meantime, the official respondents are allowed to file their respective as their counter.
I'm deeply,
In the meantime, the respondents are allowed to file their.
I'm deeply, my lord. There is an interim order, my lord.
What interim is there?
My lord, only 10 posts needs to be vacated, my lord, as per order dated 19/9/2023. Para 14, my lord.
Interim order passed ready to continue till the next.
I'm deeply,
Item 11 for hearing.
What matter is this?
It is with regards to the removal from service, Your Lordship.
When was he removed? 2014.
2001.
Does it survive?
Exactly, Your Lordship. My point for objection would be delay because he was removed in 2001. He approached Your Lordship in 2014. And the appeal was, of course, disposed of in 2009. Even then, also 5 years delay, Your Lordship.
None appears for the petitioner. List after 1 week.
Your Lordship.
1 week.
Item 12.
This termination of service, Lordship. Due to unauthorized absent, Lordship, he was terminated, Lordship.
Legal aid counsel was appointed in 2014,
Lordship,
but he has not been appearing.
Lordship, yes. In earlier occasion, he was absent, Lordship. That is 21/8/23, Lordship.
Okay, none appears for the petitioner. Mr.
A. Chakraborty,
A. Chakraborty, Leonard, Government Advocate,
Government Advocate, Lordship.
appears for the respondents. On 21/8/2023, when the matter was called up, none appeared for the petitioner. Registry is directed to intimate the learned legal aid counsel, namely Mr. M.K. Burr. Stop. List on. 29th of March, February.
Lordship. Obliged. Item 13. This matter has begun Daxas.
Matter has become. Your good name, please?
Jay Ahmed.
Mr. J. Ahmed, learned counsel for the petitioner, submits that the matter has become infectious.
I appear for respondents 8, 9, and 10.
Mr.
A. Das.
A. Das, learned counsel, appears for the respondents 8, 9, and 10.
I appear for the state.
And Mr.
D. Bora.
D. Bora, learned government advocate, appears for the state respondents. Stop. Read petition is disposed of as infectious.
Much obliged. Item 8.
May I please, your lordship. Lordship, in this case, what happened, lordship? I have been penalized, lordship, with 3 penalties, lordship, that you will find in lordship in page number. Lordship may go to the page number 81, your lordship, that is a judgment and order, lordship. I had challenged those 3 penalties, lordship, in this present case, lordship, and thereafter.
1 minute.
Yes, lord.
Yes, page 81.
Lordship, this is the paragraph, lordship, paragraph 29, lordship. On consideration so and so, it is seen that the disciplinary authority can impose the penalty of stoppage of increment for a specific period of an employee found guilty of misconduct. However, the penalty imposed till retirement is stretching the provisions of the penalty that can be imposed to absurd lengths. A specific numbers here should have been mentioned. Assuming a delinquent officer who is in her 30s or 40s is imposed the penalty of stoppage of increment till his retirement. In view of this, the code stoppage of increment till retirement in such a case would be unreasonable, and the same is not contemplated to be included within the fold of regulations so and so of the 1960 regulations. Also, there is no provision in the regulation barring the consideration of an employee for promotion during continuation of such penalty. Besides the above, there is nothing in the pleadings to show that there is any money that has to be recovered from the petitioner. As such, the objection made by the respondent number 3 in the impugn order dated so and so regarding recovery of money from the petitioner's pensionary benefit has no bearing or relevance in this case. Next para, your lordship. In the case of Vijay Singh versus State of Uttar Pradesh, so and so held that a punishment not provided in the rules cannot be imposed. Accordingly, the penalty of non-consideration of the petitioner for promotion is not sustainable in law, as the same is not provided in the regulations. The said penalty is accordingly set aside, your lordship. Now, what happened, lordship? This judgment was passed in lordship 15/11/2022.
1 minute. Yes.
Lordship. Now, if I may take you to Lordship to the penalty order, Your Lordship, that is in page number 41, Your Lordship. That is the penalty order that I have challenged in the earlier round of writ petition, Your Lordship.
Page
41. The effective portion is in page 44.
yes.
Lordship, may I read, Lordship? Imposes the penalty of stoppage of all in annual increment till so and so, that is date of for superannuation. Srimati so and so will not be considered for promotion during continuation of such penalty. In event of non-recovery of the penalty in the service tenure due to any other factor, the same or balance thereof will be recovered from admissible terminal benefits at one go. So, Lordship, this was I have challenged. This has been challenged in the earlier round of litigation, and the court has honorably set aside the penalty of stoppage of promotion till retirement. That has been set aside. So that judgment was passed in 15/11/2022. So my submission is that the stoppage of promotion till retirement has found null and void, Your Lordship. And
No, annual increment.
in thereafter, Lordship, what happened, Lordship, after this judgment, they passed another order, Lordship, at page 87, Lordship. Because the penalty of promotion till stoppage of promotion till retirement has been set aside by the Honorable Court. That is why, Lordship, they have passed a subsequent order. Page effective portion is in page 90, Your Lordship.
1 minute. Page
90.
90.
90.
Yes.
That is a subsequent order.
Is this the impugned one?
It has not been impugned, Lordship. My prayer is for that my promotion has not been considered, Your Lordship. Now what happened? My juniors have been promoted to the much higher post, Lordship. The undersigned, being the disciplinary authority, after careful perusal and consideration of all the facts, relevant documents, judgment dated so and so of the Honorable Guwahati High Court in passed in so and so, and circumstance of the matter, in excess of power conferred upon the regulation so and so, to meet the end of justice, I do hereby award the penalty of stoppage of 3 annual increments with cumulative effect, from 2020 upon the petitioner. So, Lordship, what happened? Lordship, these 3 years has already been elapsed. I have no objection with this penalty.
Okay.
I have no objection. But, Lordship, my promotion was also not been considered, Lordship, because the stoppage of promotion till retirement has been set aside by this Honorable Court. Lordship, that's why my prayer is that respondent authorities ought to have considered my promotion as if that penalty was never there, Your Lordship. Now, what happened, Lordship? My juniors, I am in the post of DGM. Recently, I've been promoted to the post of DGM in September 2023. But my juniors are in the post of CGM now, which is, Lordship, 2 rank higher than my present post. That is my permission, Your Lordship. That is the case, Lordship.
Your case has not been considered for promotion.
Lordship, in virtue of this judgment.
No, after this judgment, you are promoted, isn't it?
I've been promoted only to the post of DGM. But my juniors have been promoted to the post of DGM way back in 2020, Your Lordship. That I have brought in record by way of the additional affidavit, Your Lordship.
Where's the additional affidavit?
Lordship, I filed it on 12th, Your Lordship. That has came on record, Your Lordship.
Additional affidavit has come.
Lordship, before Lordship goes to the additional affidavit, Lordship may also take to page number 62 of the writ petition, Lordship. That is a list, Your Lordship. That is a gradation list. From that, Lordship will be clear that my juniors have been promoted, Lordship. 61, Your Lordship. The effective portion is 62. Lordship may find, Lordship, number 36, serial number 36. That is the petitioner. Lordship may come down, Lordship, serial number 43. That is Jagdish Vaishya. Lordship, if Lordship takes up the additional affidavit, Lordship may see page number 117 that the same person Jagdish Bashar who was serving as an AGM, which I was also serving as an AGM, was been promoted to the post of DGM way back in 2020, Your Lordship.
Oh.
And presently, the same the gentleman, Mr. Jagdish Bashar, is presently serving as CGM, Lordship. But of subsequent promotion orders, now he is serving as CGM.
Where's that order?
Lordship, that order is at page 92, Your Lordship, of the writ petition. The second para, in partial modification of so and so, and reservation, Sri Jagdish Bashar, GM, Narangi, AGCL is promoted to a post of CGM. Now he's presently serving as CGM.
Chief General Manager.
Chief General Manager. Lordship, the hierarchy is AGM, thereafter DGM, thereafter GM, thereafter
Presently, you
CGM.
are?
Presently, I have been promoted to the post of DGM. For 12 years, I have been serving as AGM. And my juniors have been promoted to the post of DGM way back in 2020. Thereafter, they have been promoted to the post of GM. Thereafter, they have promoted to the post of CGM. But I was kept stagnant because of the tendency of the penalty order. But that penalty order has been set aside. That particular penalty of stoppage of retirement has been set aside by the Honorable Court. Now, that's my humble prayer is that the authorities ought to have considered my promotion from the date when my juniors were been promoted to the post of DGM, because that same penalty order has been turned out as a null and void, Your Lordship. That is the only crux of the matter, Your Lordship. And so now I'm praying for a notional benefit, Your Lordship, that my promotion should have been given from the date my juniors have been promoted, that is Lordship 4/9/2020. And thereafter,
4/9?
Lordship,
4/9?
4/9/2020.
Where's that order again?
Lordship, that is the additional affidavit, Lordship. That is the additional affidavit. Page 170.
Yes, AGM.
Lordship, he was promoted from the post of AGM to DGM.
You were promoted as DGM with effect from?
Lordship. 4/10/2023. Lordship, that is page number 101 of the writ petition.
Where's your name?
Lordship, the first one only, Lordship. As per recommendation of JCC and the interest of work, Shri Vijay, sorry, Lordship. Sorry, not this one, Lordship. No, it's in here. Not that, Lordship.
98.
Page 97. 97, Lordship, page 97.
Seven 9/2023, isn't it?
Yes, Lordship. The month of September only, I have been promoted to the post of DGM. Where it is evident, Lordship, my juniors have been promoted in 2020 itself, Lordship. That is 3 years ago, Lordship. The plea of the respondent authorities is that, Lordship, due to the pendency of the penalty, that stoppage of promotion till retirement, due to that pendency, I was not been promoted. But that penalty, in my humble submission, has been interfered by this honorable court, and that is categorically been set aside, and giving liberty to the respondent authorities for give certain other penalty. And thereafter, the respondent authorities are given penalty of 3 years increment to be, that is the penalty, Lordship. penalty. Second, I'll take first. In 90. That I do hereby stoppage of 3 annual increments work.
Yes.
My lordship will kindly have the chronology of events.
Yes.
The petitioner, my lord, was appointed in the year 1991. She finally was promoted to the rank of AGM on 30th of July 2014. My lordship will kindly make a note. That order, lordships, find at page 36 of the writ petition.
36.
36. She was promoted to the rank of AGM. my lord.
Hmm.
So now in the year 2016, my lord, the disciplinary proceeding was started.
Hmm.
36 is the order, my lord. Lordship finds her name at page number 38. From manager to the post of AGM. Now, from the post of AGM,
Where's the petitioner's
at the page 38 at the top, my lord.
Lakshmi
Yes,
Laskar?
Vijay Lakshmi Laskar.
Oh.
That is the manager is promoted to the post of assistant general manager.
Mhm.
She was holding the post of manager. Now she is the promoted to assistant general. Now, under the rules, my lord, for being promoted from AGM to DGM, the minimum service is 5 years. So she has to be an AGM for a period of 5 years. So this order is dated, my lord, 30 July 2014. So she becomes eligible for promotion in the year 2019. Am I clear, ma'am? Now, disciplinary proceeding is started against her in 2016. So lordship knows that when a disciplinary proceeding is pending, if the DPC sits, my lord, the result of her consideration has to be kept in a sealed cover. Seal cover cannot be opened if any punishment is imposed, my lord, it is settled law. Now, order of punishment is imposed on 27/1/2020. Page 41, it starts. My learned friend has already read the operative portion, my lord. At page 44 is the typed copy. I am not troubling your lordship, my lord. Because the punishment was imposition of stoppage of all annual increments till her date of superannuation. And she will not be considered for promotion, my lord. I have to concede, my lord, that this penalty was not prescribed in the rules. And on that very ground, my lord, this honorable court interfered. Now, my learned friend is arguing that because of the interference by this honorable court, this penalty has been rendered null and void. With utmost respect, my lord, had this honorable court exonerated the petitioner, then I could have understood that this punishment becomes null and void. But the matter was ultimately remanded, man. It is not that this honorable court has come to a finding that she was innocent, man.
It was set aside.
It was set aside and remanded for fresh penalty, man.
Yes.
This penalty goes, but fresh penalty is imposed. So fresh penalty will relate back to the original order, my lord.
How?
Yes, my lord, because lordship will kindly see the fresh penalty.
Hmm.
Fresh penalty is not imposed from 2022, my lord. Fresh penalty is imposed with effect from 2020. I'm reading the order of penalty, my lord, at page 87. Page 90 is the effective portion.
Hmm.
Undersigned being the discipline authority after careful perusal, consideration, so and so, so and so, I do hereby award the penalty of stoppage of 3 annual increments with cumulative effect from July 2021.
Hmm.
It is not with effect from 2022 or 2023. It is with effect from July 2020. So for 3 years, that means from July 2020 till 2023 of July, this punishment is in operation. Now lordship will come back to the date when the juniors were promoted. Juniors were promoted, my lordship, my learned friend has placed in the additional affidavit. It is 4/9/2020.
Yes.
So on 4/9/2020, the earlier order of punishment was 27/1/2020. So on 4/9/2020, the order of punishment subsists. So therefore, when the petitioner's junior was promoted, the order of penalty is there, my lord. I'll be relying on 3 Supreme Court judgments, my lord, which says that when an order of penalty is in operation, a person cannot be, an employee cannot be promoted. Because promotion is not a matter of right. The right is only for consideration of promotion.
Hmm.
One is that, my lord, the case of Janaki Raman, lordship, that celebrated case of Janaki Raman, my lord. 1991, 4 SCC, page 109, my lord. Para 29. Lordship has got it. There it was a case of seal cover. It has been categorically held that a seal cover cannot be opened when a penalty is imposed. 29, my lord. According to us, the tribunal has erred in holding that when an officer is found guilty in the discharge of his duties, an imposition of penalty is all that is necessary to improve his conduct and to enforce discipline and ensure purity in the administration. In the first instance, the penalty short of dismissal will vary from reduction in rank to censure. We are sure that the tribunal has not intended that the promotion should be given to the officer from the original date, even when the penalty imparted is of reduction in rank. On principle, for the same reasons, the officer cannot be rewarded by promotion as a matter of course, even if the penalty is other than that of reduction in rank. An employee has no right to promotion. He has only a right to be considered for promotion. The promotion to a post and more so to the selection post depends upon several circumstances. To qualify for promotion, the least that is expected of an employee is to have an unblemished record. That is the minimum expected to ensure a clean and efficient administration and to protect the public interests. An employee found guilty of a misconduct cannot be placed on par with the other employees, and his case has to be treated differently. There is therefore no discrimination when in the matter of promotion, he is treated differently. The least that is expected of any administration is that it does not reward an employee with promotion retrospectively from the date when for his conduct before the date he is penalized in precedent. When an employee is held guilty and penalized and is therefore not promoted, at least till the date on which he is penalized, he cannot be said to have been subjected to further penalty on that account. A denial of promotion in such circumstances is not a penalty, but a necessary consequence of his conduct. In fact, while considering an employee for promotion, his whole record has to be taken into consideration. And if a promotion committee takes the penalties imposed upon the penalty employed into consideration and denies him the promotion, such denial is not illegal and unjustified. If further, the promoting authority can take into consideration the penalty or penalties awarded to an employee in the past while considering his promotion and deny him promotion on that ground, it will be irrational to hold that it cannot take the penalty into consideration when it is imposed at a later date because of the pendency of the proceedings, although it is for conduct prior to the date the authority considers the promotion. For these reasons, we are of the view that the tribunal is not right in striking on the said portion of the second so-and-so. So therefore, in my respectful submission, my lord, when the order of penalty is in operation, my lord, can he claim promotion? And lordship will kindly see the misconduct. Misconduct is of theft of electricity. Being an AGM, my lord, she had tampered with the meter in her house. So the Supreme Court has held, my lord, that when an employee is penalized by promoting him or her, she cannot be rewarded for her misconduct. It is a case where she has been held guilty. The order has been interfered with by this honorable court. My lord, the order has been interfered with by the honorable court as being excessive, my lord, disproportionate to the gravity of the offence. It is not that the High Court has said that no, she was innocent, it is interfered with. Lordship reads the judgment, my lord. This judgment is, the order is set aside and matter is remanded for imposition of fresh penalty. That fresh penalty order, my lord, admittedly is not under challenge. So she accepts that she was guilty. She has accepted the punishment of reduction of the, my lord, the increment, my lord, withholding of the increment with cumulative effect. So the punishment is in operation from July 2020 till July 2023. Lordship sees the promotion of our juniors is in September 2020. And immediately thereafter, when the punishment, the operation of the punishment is over in July, my lord, in September, she has been promoted. That is page 97 of the writ petition. Now, when our juniors have been promoted to the subsequently higher levels, my lord, she remained as AGM. Now, if we have to give her retrospective promotion, my lord, it will be directly hit by this judgment, my lord. Then another one, my lord, 1995 3 SCC, page 273. Para 7, my lord. 1995, 3 SCC, page 270. Para 7, my lord. Lordship has got it. It would thus be clear that when promotion is under consideration, the previous record forms the basis, and when the promotion is on merit and ability, the currency of punishment based on previous records stands as an impediment. Unless the period of punishment gets expired by a flux of time, the claim for consideration during the said period cannot be taken. Otherwise, it would amount to retrospective promotion, which is impermissible under the rules, and it would be a premium on misconduct. Under these circumstances, we are of the opinion that the doctrine of double jeopardy has no application for, and non-consideration is neither violative of Article 21 nor 14 read with Article 16 of the Constitution. So here an argument was advanced that since I have been imposed with a punishment, denial of promotion is amounts to double jeopardy. Apex Court has said no. Your conduct, your denial of promotion is a result of your conduct, previous conduct. Now on similar lines, my lord, 1992, Supply 3 SCC, page 50, my lord.
Supply
3 SCC, page 50. Para 4, my lord. Here a particular rule was under consideration, para 4. We have considered the matter closely, and in our opinion, the view taken by the tribunal, both in the impugned judgment in the earlier decision holding, that as a result of the provisions of Order Rule 157 forbidding the promotion of a state employee during the currency of the penalty results in second punishment is not correct. There is only one punishment visiting the respondent as a result of the conclusion reached in the disciplinary proceeding, leading to the withholding of increment. Here also the increment was withheld. And a denial of promotion during the currency of the penalty is merely a consequential result thereof. The view that a government servant, for the reason that he is suffering a penalty or a disciplinary proceeding, cannot at the same time be promoted to a higher level is a logical one, and no exception can be taken to Rule 157. It is settled, no, my lord. It does not amount to double jeopardy. Again, it is reiterated, my lord. It is correct to assume that Rule so and so binding is subject to government or consent to double jeopardy. We do not find any merit in the argument, and there is no justification or rationale behind this policy, nor do we see any reason to condemn it as unjustified, arbitrary, and violative of Article 14. Now, so far as this case is concerned, also here also, my lord, the promotion rule, I'll provide the rules, my lord. Rule 14 says the promotion has to be done by DPC selection committee. So merit has to be considered. You are guilty, punishment has been imposed, you cannot be promoted, madam. And if your lordship, as I have already pointed out, lordship sees the chronology of dates, she has been considered. Once the punishment is over on 30th of July 2023, she has been promoted in 7th of September. So they cannot be said that we have altogether, we have either violated the order of the High Court, because the earlier order was not to deny promotion till the end of her service. That has been interfered and she has been promoted. So there is no wrong committed by the APDCL authorities, my lord, in not promoting the petitioner, and the decisions is in my affidavit, my lord. The minutes of the meeting of the DPC that your lordships will find at page 111. Third para from bottom, my lord. Moreover, that is pertaining to the petition. Moreover, the committee noted that departmental proceeding drawn up against Sri so-and-so, that is the petitioner, was disposed of in terms of the judgment dated so-and-so of the Honorable High Court in WPC so-and-so as stoppage of 3 annual increments with cumulative effect with effect from July, and our penalty period will expire on 1/7/2023. Accordingly, the committee opined that the matter of promotion of to so-and-so will be placed before the JCC as she belongs to the common cadre category of employees only after the expiry of her penalty period. That was done, my lord. Page 112, lordship comes. This is the relevant extract of the minutes of the JCC. Point number 3. She has been promoted, my lord. The committee perused the matter of promotion of C so-and-so to the rank of DGM after detailed discussion.
JCC?
Is the joint committee, my lord.
Joint committee?
Joint, I'll get back to it. I have stated in my affidavit, my lord. It is the Joint Consultative Committee.
Joint consultative.
Page 107, lordship will find. 7th line from the top. It is the Joint Consultative Committee. That is those aspects I am pointing out, but those aspects are not under challenge before this honorable court. Neither those minutes are under challenge, nor the order of penalty. The prayer made is for a writ of mandamus, my lord. Page 23. No certiorari, no prayer for setting aside those minutes, my lord. He is seeking a mandamus that in terms of the earlier judgment, I reiterate, my lord, has not interfered with the with the misconduct, my lord. It is only with the quantum of the penalty. Matters to remanded. We have imposed fresh penalty. That has not been challenged. And I have shown, my lord, the law is settled. During the currency of a penalty, you cannot be promoted. And in fact, in another judgment, may not be very relevant, my lord, because it was a case of where the DPC had kept it in sealed cover. 1998, I may just point out, 1998, 9 SCC 261. 1998, 9 SCC 261. Where the punishment of censure was imposed, my lord. I'll hand over a copy because it's a short judgment. Punishment of censure was imposed Para 8, my lords. We are unable to accept, I'm reading slowly. We are unable to accept the said contention of so and so. Censure cannot be equated with a warning under rule so and so of the so and so service rules. Censure is one of the minor penalties that can be imposed on a government servant. It cannot therefore be said that the penalty of censure which was imposed on the respondent in the departmental proceedings was not a penalty as contemplated. Once it is held that a minor penalty has been imposed on the respondent in the departmental proceeding, the direction given in the said circular would be applicable and the seal cover containing recommendation of the DPC could not be opened and the recommendations of the DPC could not be given effect. So even if there is a DPC and the matter is kept in seal cover, my lord, if a punishment is imposed, even the seal cover cannot be opened. Here, of course, that situation is not arising. That is why I have not placed it earlier. Here there was no DPC because the promotion of the juniors, as my learned friend had pointed out, has taken place in September 2020. And thereafter, they have, by the usual course, the others have been promoted, man. The punishment was in operation. That is why she could not be promoted. She has been promoted in September. That is my respectful submission. Deserves no interference, man.
My apologies, my lord, I was in some other court. No, my lord, the matter before your lordships, my lord, in simple words. Now, my lord, lordship, my learned friend has already narrated the chain of events. Now, I am an employee of the APDCL, my lord. My lord, I'll just point out the hierarchy for a moment. There is the post of Assistant General Manager. The next promotional post is Deputy General Manager, DGM, then the General Manager, then the CGM. So what had happened in this instant case, my lord? I have been penalized by the authorities, by APDCL, and there was a penalty imposed, my lord, that my three increments would be stopped for 3 years. Now, my lords, with the 3 increments, now if the submission made by my learned friend is to be accepted, it would mean that I would lose out on 3 increments, and at the same time, I would also lose out on the promotions, my lords. My promotions, which my juniors were already promoted. Now, my lords, the judgment, with all due respect, which has been referred to by my learned friend, that pertains to a circular. In that case, my lords, there was already a circular to that effect that if there was a penalty imposed under that specific rule, that there cannot be any promotion in the currency of that period, my lord. Now, my lords, to simplify, I won't trouble your lordship with the records, my lord. The initial penalty which was imposed, my lord is aware. In the initial penalty, there was the penalty of stoppage of increments till retirement. That was the first penalty. The second, stoppage of all promotions till retirement. And there was another, which was recovery. Now that was put to challenge, my lord. The lordship has seen the judgment of the single judge. The learned single judge has held that the penalty of stopping promotion is not even contemplated by the rules. Hence, you cannot, by referring to various judgments, hence you cannot impose that penalty of withholding of all promotions. At best, you can impose the penalty of withholding increments, but that was accordingly set aside. Now, my lords, I asked this question to myself. Now, if what my learned friend has submitted, that if a penalty of stoppage of increment would also mean a penalty of stoppage of promotion, then in the first place, the disciplinary authority ought not to have passed 2 punishments. You stop my increment, you stop my promotion. Both operates in different fields. One is increment, one is promotion. Now that was set aside by the honorable single judge. Now, upon that being set aside by the honorable single judge, after the decision of the single judge, if I'm still denied the promotions, that would amount to contempt of the honorable single judge's order. Honorable single judge has clearly held that you cannot stop the promotion, you can stop the increments. Now, this judgment which has been relied upon
In that case, there was a circular, and I agree, my lord, even the government of Assam had a circular. I couldn't get it today, my lord. Government of Assam has a circular which says that sometimes in some penalties, during the currency of the penalty, you may not be considered for promotion. But that is not the case of the APDCL. Now, coming to one point, my lord. Now, things would have been different if the promotion was on the basis of merit come seniority. Because in that case, even a junior can supersede a senior. Now, what I've been told by the client, my lord, subject to what my learned friend says, my lord, these promotions, AGM, DGM, GM, and CGM, they are time-based, my lord. You be in that post for a certain time, then you are promoted to the higher post on the basis of seniority alone and nothing else. Now, my lord would kindly come to, just to show how am I prejudiced, my lord, promotion.
That is not correct, man.
In any way,
It is on solely based on promotion. Seniority is not correct. It is both on seniority and merit, man. Had it been on seniority, because there are marks allotted, my lord, for various things, my lord. 5 years ACRs are to be looked into, my lord. If it is outstanding, it is 10 marks. It is very good, it is 8 marks. And work experience, the qualification, everything is there in the notes.
That is the convention, my lord. Seniors have been promoted. I'll show it from the record. So my lords would come to the gradation list, my lord. Page 61 of the writ petition. Kindly for a moment, my lord. It will amount to double jeopardy, my lord. They'll inflict one penalty, and for that penalty, another penalty has been invoked. My lords, page 61. My lords, this is the gradation list of assistant general managers. Assistant general managers, so and so, so and so. Now, my lord would come to page 62 for a moment. I am at serial number 36, Srimoti Bijoy Lakshmi Loskar. This gradation list is dated 31/10/19. Thereafter, my lord, the penalty was passed that my promotions would be stopped. The penalty was operating, but end of the day, my lords, the honorable single judge had set aside that penalty, and thereafter a modified penalty was imposed whereby my promotions were withheld. Now, in the meantime, during that period, my lords, all my juniors from 36 below, now they are in the post of CJM. For example, my lordship would come to the serial number 37, Srimoti Arati Chetia. My lordship would take up their affidavit for a moment, just for a moment, the first page.
What's the affidavit?
My lord, the affidavit filed by the APDCL. The first line, my lord.
First?
The first line of the affidavit, I, Srimoti Arati Chetia. Now, paragraph 1, that I am the Chief General Manager, HRA of the APDCL. Now, my lords, my junior, and the others, my lord, for which I have appended, my lords, promotion orders, during that period where I was penalized, no promotion, my juniors became DGM. From assistant managers, were together as assistant managers. They became DGMs. From DGMs, they became general managers. And from general managers, they became chief general manager. And now, because of that penalty, which has been finally set aside by this honorable court, I have been denied of 2 promotions, my lord. I am still at the stage of DGM, where my juniors, who were junior to me, and that's an admitted fact, my lord. That's not been denied in the affidavit. My juniors were promoted to the post of CGM, Chief General Manager. Now, the ground taken in the affidavit, what I have understood from the affidavit, is that, my lords, I could not have been promoted. I was not promoted, rather, because of the fact that the penalty, final penalty, was for a period of 3 years. Now, what was the penalty? The penalty was withholding of increments, not withholding of promotion. By saying that, by taking that stand, they are withholding my increment. They're also withholding my promotion, which has been specifically set aside by the honorable court. They have said nothing doing, this is illegal, you cannot do that. You cannot stop the promotion. You can give just one penalty, my lord. In fact, this stand is covered. And why I rake the issue of seniority, because as per convention, what I'm seeking now as a prayer, I'm seeking that I should be promoted on the date when my immediate junior was promoted. That's the next below rule. That's the rule of the Supreme Court, my lord. I should, if I was deprived, I should be promoted on the day when my junior was promoted. Now my juniors went to CJM. I'm still in the stage of DGM because of the wrong interpretation of the judgment. They say because there was 3 years of withholding of increments, that's why that 3 years you won't get promotion also. My lords, this exact stand, my lords, this issue was raised in a matter where this honorable court has passed a judgment which should squarely cover the matter. My lords, I'll just this is the judgment of Honorable Justice S.N. Fukon. This is 95. Data detail. My lords would come to paragraph 7, my lords. May I read, my lords? Paragraph 7.
Yes.
It may be stated that while forwarding the inquiry report of the letter,
No, one
Se-
minute, 1 minute.
paragraph 7.
I don't have paragraph 7 here.
My lords,
Oh, it's
it's double, yes, my
Yeah,
lord,
it's
because
okay,
it's
yeah.
1991. Maybe that's it. My lords, has it now, my lord? It may be stated that while forwarding the inquiry report, so-and-so the letter and so-and-so was sent to the petitioner by the principal secretary informing him that the district council decided to inflict minor punishment subject to the approval of this court. The said proposed punishment is, now this was challenged, my lord. All your increments and pay henceforth will be stopped and you will not be considered for any promotional post, if any. Now, same kind of order, my lord, the initial order, that my increments till retirement, my promotions till retirement. Now, what was the submission of the council appearing for the petitioner in this matter? My lord? Paragraph 9. The first point urged by Sri Sharma is that the proposed punishment is bad in law, in as much as not only the increments of the petitioner would be stopped for future, but he would be debarred from getting any promotion to the next higher post. According to Sri Das, withholding and stoppage are different, and therefore such a punishment can be inflicted. Drawing attention to Rule 8 of the Assam Services Discipline and Appeal Rules 1964, which has been adopted by the District Council, Sri Das has urged that according to Sub-Rule 1 of Rule 8, the authority can impose one or more penalties as specified in Rule 7. Therefore, there is no illegality, according to Sri Das, in the proposed punishment. Now, my lords, paragraph 10, clause 2 of Rule 7 of the said rules runs as follows: withholding of increments or promotion. Now, the service rules, what we follow, Assam government, as per 7, the penalty 7.2 says withholding of increment or promotion. So you can either withhold the increment or promotion. Now, same is the case, my lord, in our APDCL conduct rules, there is only withholding of increment and not withholding of promotion. And that is the specific reason why the Honorable Court had set it aside when there was withholdment of promotion also. Therefore, my lord, after this, my lord, therefore, the intention of the rule maker is very clear that the authority cannot impose the punishment of withholding of increments and promotion. Only one punishment can be imposed, namely either withholding of increments or promotion. In view of the above legal position, I find considerable force in the submission of Sri A. Sharma to hold that the proposed punishment is not in accordance with law. My lords, in the case which I'm reading, my lords, there was a provision in the rules which allowed the disciplinary authority to either withhold increments or withhold promotion. Now, in that case, the authority could have imposed the penalty of promotion, but if they would have issued that penalty, the other penalty could not have been imposed. Now, in our case, my lords, admittedly, there is only withholdment of increment, and the penalty of withholding of promotion is not even there in the rules. I know rules, sir.
Where are the rules?
Rules are,
No, we have not withheld the promotion, madam, now. She has been promoted in September.
that's why I'm coming to that. I'm replying to that. My lord.
Okay.
Hmm?
Okay, then.
Lordship would see, well, at the bottom, reprimand, warning, my lord, the penalties are specified the same page only, my lord. And there's the penalty of withholding of increment. There is no penalty of withholding of promotion.
This is Rule 10.
Rule 10, my lord. Rule 10, these are first the conduct of the officers, then the punishment which can be.
What are the full rules?
I'll provide the full rules, my lord. I thought that was relevant, the penalty, that's why I just got a copy. I'll produce it if required. So what I'm trying to point out that as per this rule, there is no provision of stoppage of promotion. And hence the reason the Honorable Court interfered with the first penalty order, where there was, apart from the penalty of withholding of increment, there was another penalty that your promotion will also be withheld till the time of retirement. Stoppage of increment for a specified period is there, my lord, only for a specified period. And that's why it was interfered. And thereafter, the modified penalty was issued, whereby they had only issued the penalty. I'll take your lordship so that modified penalty, my learned friend has submitted that I have not challenged it. I need not challenge it because the penalty says that my increments will be withheld. The penalty does not say my promotions will be withheld. It is for the first time in the affidavit they have taken this stand that during the currency of the 3 years withholding of increment, my promotions would also be stopped. Now, my lords, one very subtle, my lords, aspect, if I may say so, my lord, if I may point out. Now, going by the stand taken by the respondent authorities, they are now saying that during that 3 years of stoppage of increment, my promotions will also be withheld. Now, that puts me back to the same position. Why I came before the Honorable Court in the first instance, my lord. Now, had that been the case, why would they have issued the penalty, the first penalty, issuing 2 penalties, withholding of increment and withholding of promotion, because they were aware that those operate in 2 different fields.
Where's this regulations? Regulation 1960. This is the one.
Yes, 1960.
Where's the 10.2 within bracket A?
Yes, my lord, he has the regulation. Now, come after my lord goes through it, I'll.
You have a spare copy?
Lordship, no.
Lordship may.
I'll make it right now.
Okay.
No, later.
We'll take up tomorrow. You bring a copy.
My lord, I'll bring it.
Just finish it off tomorrow.
Yes, sir.
When are you retiring?
No, 29th of this month.
20.
Or maybe on a hearing day before 29th. if my
Yes.
lord-
We can have it on 20.
My lord.
Okay, heard Mr.
P. Mohanta, my lord.
P. Mohanda, Learned Counsel, APDC. Also heard Mr.
And they come up.
M. Dekar, Learned Standing Counsel, APDC. Heard in part. This for Friday hearing on 20.
20th. sir.
20.
Judgment will be kept on record, my lord.
This are kept on record.
I'll make copies of it.
My lord, heard in part. My lord.
Yeah.
Deeply blessed. Very grateful, man.
No, the ACP Officers Conduct Rules 1982.
No.
na? I have a soft copy.
20th of
1960. no, right?
1960. I think I may be having a soft copy. my lord. It's not in my pack.
Just make copies, my lord. And
Just get the copies, Dekar.
Yes, my lord. I have it. I have a soft copy. my lord. I can email it.
Get a copy.
I'll get it. I'll get it printed.
Time being item 6.
May I please tell us? My lord, in this case, my lord, we are the casual worker, my lord, have been engaged by the state government, and we have been engaged on 29/9/1995 and 6/11/1995. Page 31 and 32. Our engagement, my lord, page 17, page 17, page 18, page 19. As in, my lord, chairman and the peon, my lord. And we have been working continuously, my lord. This has been certified by the time to time, work certificate has been issued. Subsequently, my lord, to get regularized our services, my lord. To get regular, we have prayed for a regularization and
You are appointed as what? Master role?
master role. The chairman and peon, grade 4 post, my lord. In a grade 4 post, page 16 and 18 is our joining order, my lord. Kindly see page 16 and 18. Sri Ranjit Das, petition number 1, is hereby engaged as a chairman against the post branches mentioned against for a period of 2 months. And 18, my lord, kindly see as a chairman Sri Munlian Chorai. This is our engagement order.
Munlian.
Munlian Chorai.
Two petitioners?
Two petitioners. One is Munlian Chorai, another is Ranjit Das. Thereafter, my lord, kindly see page 20. Order Sri Mulyan Chorai is hereby entrusted to work in election branch in DC office, Karimganj, temporary as an casual employee. These are, my lord, some orders where we have been appointed, we have been engaged in various works by the deputy commissioner as a casual employee. These are the certificate, page 20, 21, 22. These are the certificates, and we have been discharging our duties in various posts pursuant to the order passed by the deputy commissioners. Thereafter, my lord, page 25, Deputy Secretary to the Governor of Assam issued letter to the Deputy Commissioner at Karimganj. This is the order dated 18 September 2001, my lord. Subject regulation of service of chairman. I am directed to refer to a letter number on the above subject and say that it appears from the statement furnished by you that there are 10 numbers of SK in Karimganj district, but we have sent proposed for 13 numbers of chairman for regulation, which seems to be very high and unreasonable. Therefore, you are requested to furnish a detailed report on the matter with justification, etc. on the GOP immediately. In regarding our, my lord, services, the Deputy Secretary should letter to the Deputy Commissioner to furnish our reports, man.
What is SK?
SK, these are called chainmen, my lord.
SK? No, SK can be a chainman.
Supervisor Kanungo.
Huh?
Supervisor Kanungo.
Kanungo.
Supervisor?
Kanungo.
Kanungo.
He is that after Mondol Malat, next promotion is SK. It is Supervisor Kanungo.
But we are not SK, my lord. We are chainmen in grade 4 peon postman. Page 27, my lord, thereafter. Sri Shyam Jagannath IS, Commissioner and Secretary to the Governor of Assam Finance Department, to all administrative department. Subject checklist to be submitted by the administrative department for compliance of Honorable High Court order dated 8/6/2017 passed in readable number so and so, Finance Department letter number so and so. With reference to the above, I am directed to state that in pursuant to the Honorable Guwahati High Court's order dated 8/6/17,
First in Rate Appeal number so and so 45/2024, State of Assam versus Upendas and others. A committee has been constituted in Finance Department to scrutinize the list of master role, work charge, fixed pay, casual, etc. workers who have been working with the state government since last more than 10 years, but without sanction post. And to comply with the aforementioned High Court's order, the committee has prepared a checklist containing Annexure 1 and 2, which has to be submitted to Finance Department not later than 31st September 2017. I am therefore to request you to kindly submit the consolidated list of master role, work charged, fixed pay, casual, etc. worker who have been working with the state government for the last more than 10 years, but without sanction post, both in hard and soft copy, under the jurisdiction of your administrative department as per format checklist enclosed herewith not more than 31st December 2017. That letter was issued, my lord, on 9 October 2017. Accordingly, my lord, page 30, Commissioner's Finance Department to Commissioner Secretary to the Governor of Assam, another letter was issued, my lord. In inviting reference to the, this is in regards to the payment of minimum pay scale. To the page 30, my lord. 30. This is regarding, my lord, regarding payment of the master role worker. This is issued by the Commissioner Secretary to the Finance Department to the Commissioner Secretary to the Governor of Assam. Payment of minimum pay scale to the master role, work charge, casual and similarly placed who were appointed prior to the AFRMB period workers in persons of the Honorable High Court order dated 8/6/2017 in detail number 45/2014. In inviting reference to the letter on the subject cited above, I am directed to forward herewith the list of master role, casual, fixed pay, and similarly placed workers who were appointed prior to AFRMB period received from your department since approved and duly authenticated by the Finance Department to extend the benefits of payment of minimum pay scale to the master role, casual pay, etc. workers in persons of Honorable High Court's order dated so and so. The Administrative Department are requested to strictly follow the guidelines indicated below. The posts are personnel to respective their master role, so placed work will be abolished as soon as the incumbents relinquish the post in the manner. The ban on fresh engagement of master role workers also. These are the some conditions which does not comply as my lord. We are not covered with these conditions. My lord, therefore, page 31. Principal Private Secretary to the Chief Minister Assam issued a letter to the Deputy Commissioner Karimganj, a regulation of service matter. As direction, I have honored to send herewith the prayer petition received from Sri Munlen Chorai via official email registered by this office ECN number so-and-so dated 17/11/2022. However, the letter is self-explanatory. As directed, I would like to request you to kindly look into the matter and take necessary action as deemed fit and proper. Thereafter, my lord, kindly see page 34. Page 34, my lord. The Deputy Commissioner submitted details to the Principal Secretary to the Governor of Assam Revenue and Disaster Management Department regarding regulation of services of Sri Munlen Chorai and Sri Ranjit Das, casual grade 4 employee of the Office of the Deputy Commissioner Karimganj. Reference email number so and so. In inviting reference to the above, I have the honor to state that Sri Munlen Chorai and Sri Ranjit Das have been working in the Office of the Deputy Commissioner since 1995 under various capacities as casual grade 4 employees without the service being regularized. In this context, it may be mentioned that as prayed by Sri Munlen Chorai and Sri Ranjit Das, email under reference, this office have received correspondence under reference from the Office of the Honorable Chief Minister Assam, which request to look into the matter of regulation of the service and take necessary action thereof. The incumbent had earlier prayed for regularization of their service earlier, however, without any result in this regard. Now it may be mentioned that as per notification number so-and-so, 2019, casual employees appointed prior to FRMB period may be paid as per minimum pay scale in persons of the Honorable Guwahati High Court's order dated 8/6/2017, passed in Rate Appeal number 45/2014, State of Assam versus Upendas and so and so.
In this regard, the details of the employees are furnished as per format mentioned in notification number by number FPC so and so 9th October 2017 for favor of kind perusal necessary consideration. In view of the above, necessary instruction is solicited to take apt action in the matter of regularization of services of two casual grade 4 employees as per instruction under reference received from the office of the Honorable Chief Minister. That is, my lord, Deputy Commissioner submitted details report to and page 35, my lord. These are our details, my lord, services.
Yeah, then what happened?
Everything is submitted to the Deputy Commissioner. Thereafter, my lord, we have challenged this order, page 36. Page 36, matter of regulation of service of Sri Mulan Chorai, that is issued by the Deputy Secretary to the Government of Assam Revenue and Disaster Management to the District Commissioner Karimganj. Matter of regulation of service of Sri Mulan Chorai so and so. With reference to the above, I am directed to intimate the views of Finance Department regarding regulation of services of Sri Mulyan Chorai, Sri Ranjit Das, casual grade 4 employee of the Office of the Deputy Commissioner Karimganj as quoted below. It is mentioned that by order of the Honorable Guwahati High Court dated 8/6/2017 in readable number 45/2014, State of Assam versus Window Master Rule Work Charge, Fixed Pay, Casual, etc., who have been working in the state government for last more than 10 years, but without sanction posts were extended minimum to pay scale as per the list received from the administrative department. As per available record, proposal in respect to the two incumbents, namely Sri Mulyan Chorai and Sri Ranjit Das, were not received by the finance department. It is pertinent to mention that finance department has in the meantime adopted sunset clause as per the direction of the higher authority and with the approval of the Honorable Finance Minister Azam, and all administrative departments have been informed accordingly. This for your kind information necessary action. And this is the judgment, my lord, Upendra Sir. So, my lord, here in this case, we are covered by this judgment, which has been admitted by the respondent authorities. That we are entitled for the remunerations, fixed base, and some other benefits as per this Upendra judgment. But they are saying that Deputy Commissioner sent, but they did not receive. My humble submission, my lord, this is the fault of the respondent authorities, and due to the lack of communication, we are the sufferer and we should not be the sufferer.
Yes.
My lord, we are entitled under this judgment. They admitted that, my, but our documents have been sent time to time, my, but they did not receive, my. So this has been sent by the Deputy Commissioner. So it is the fault of the respondent authority. Due to their fault, my lord, we should not be the sufferer. We are
So
entitled by this judgment.
What are you claiming?
I am claiming, my lord, we are entitled for under this Upendra's judgment, undoubtedly, my lord. So we are claiming the benefits under this judgment.
What benefits?
These are the, my lord, minimum pay scale, my lord, which has been mentioned here.
When you're in your prayer portion, you're praying for regularization.
Fair person, they are seeking regularity.
My lord, pass orders passed by any other, this honorable court, my lord, we are entitled, my lord. My lord, here, my lord, in pair portion, pair number 3, my lord. Direct the respondent number 1 and 2 grant service benefits to the petitioner in persons of the order dated 8/6/2017, passed and writ appeal number 45/2014.
What service benefits?
These are the benefits which has been granted by this honorable, this open the judgment, my lord.
What benefits was granted?
The minimum pay scale, my lord.
That's all.
Minimum pay scale, my lord.
That's all.
Which is, my lord, there are some other employees, my lord, who has been granted benefits.
State government came with a proposal that you will not be terminated, but you will be adjusted in so and so department. The court accepted that proposal. And then at the same time, in view of Jagjit Singh's case, court division bench said this master role and all the similarly situated should be given the minimum pay scale. That's all.
That's all.
Nothing much.
Should be given to minimum pay scale and not to terminate, my lord.
You're still serving, isn't that?
Still serving, my lord.
Then-
Yes, my lord. Minimum pay scale.
Termination does not arrive. They are still working.
Yes,
But
sir.
only because of my lord that they have to my lord pay the minimum scale of pay.
Are you being paid the minimum pay scale?
No, my lord. Not paying. Not paying. No pay scale is giving, my.
You can give
We are working, my lord, time to
No,
time.
so what is your prayer here?
Prayer, my lord, we are,
Your prayer and your in the writ petition is totally opposite to
My lord.
what is there in Opindas.
we are praying, my lord, minimum pay scale person to this judgment, person to the Upendra's judgment.
Where's that prayer in your writ?
Prayer, my lord, page number 12, prayer number 3, my lord.
What service benefits?
Service benefits, my lord, it includes maybe minimum pay scale or whatever the benefits have been provided by the other employees, my lord, who have been already absorbed by way of this judgment. We have been left out, my lord. So we may have provided this benefit which has been provided by the other employees, my lord, pursuant to their judgment. Because government has already given benefits to the others, my lord, pursuant to their judgment, my lord. So that may be, it may be minimum pay scale or some other benefit which they are providing to the other employees, my lord.
What are they providing to the other employees? Minimum pay scale?
Minimum pay scale,
That's all.
that's all.
And they're
And
continuing-
it is better they knows, man. They know this, what they are giving this benefit to the other employees.
Yes. And they,
Lordship. My lord, you are giving the minimum pay scale only, my lord.
are you paying them?
Lordship, my lord, that my learned friend can say, my lord, that.
You are for the revenue.
I'm for the revenue, my lord, he is a deputy commissioner.
I'm for the deputy commissioner. That information is not there, your lordship. Only question,
No, one thing is this. If you are paying them the minimum pay scale, as on today,
Right.
matter ends there.
that is-
Nothing more
Nothing
to
more.
consider.
yes.
You take that instruction and come back.
Yes, and also your lordship,
Otherwise, there's nothing more in Obindas.
Lordship, lordship.
They will not be terminated, and once they relinquish their post,
then
that post will be abolished,
abolished.
right?
Yes.
And in the meantime, minimum pay scale should be paid to them. So
Yeah.
I just want to know whether petitioners are being paid the minimum pay scale. Number one, they are not being terminated, they are continuing. So there's no issue on that. So just get that small instruction, come back tomorrow.
And your lordship, there is only one particular issue that needs to be clarified by the finance department, because the letter that they have challenged here, that is the page number 36, annexure 9.
Page
36, annexure 9.
Hmm.
Now, in last paragraph, second last paragraph, it is pertinent to mention that particular paragraph, as your lordship got it. It is pertinent to mention that finance department has in the meantime adopted sunset clause as per the direction of the higher authority and with approval of the honorable finance minister, and all administrative departments have been informed accordingly. So this is in favor of, this is for your favor of kind information and necessary action. So what is that particular sunset clause? Otherwise, we have written to them at page number 34. In terms of this particular, if your lordship may kindly come to page number 34. At paragraph number 3, now it may be mentioned that as per notification wide finance notification dated 8 March 2019, casual employees appointed prior to FRBM period may be paid as per minimum pay scale. In pursuance of Honorable Court's order dated so and so in W Writ Appeal 45. Now, the only question that needs to be determined, Your Lordship, whether this notification has a sunset clause or not. Now, if there is a sunset clause, then of course they are not entitled. But if it doesn't have that particular sunset clause, then the petitioner is entitled.
Where is this notification?
So that my learned friend from Finance Department.
To verify whether sunset clause is applicable or not, my lord, in this case. But should be not 1 week. 1 week.
So otherwise, I don't think they have been paid the minimum pay scale. Because had they been paid, I think they
Okay,
have not.
heard,
written.
Mr.
Only because of that, my lord.
HR Chowdhury,
Sunset
General
clause.
Counsel for the Police. Stop. MS R. Barwal, Learned Counsel, appearing on behalf of Mr. B. Gogoi, Learned Standing Counsel, Finance Department, shall produce the notification number FEC within bracket Roman 2 4/2014/413 dated 8 March 2019. Okay, is that correct?
Yes, lordship.
You're on that.
Notification.
And another one.
Next paragraph, FPC.
And also the notification number FEC within bracket Roman 2 4/2014/356 dated 9th October 2017. So, in the meantime, Mr.
D. Bora.
D. Bora, Learned Government Advocate, shall also get instructions. Shall also receive instructions as to whether the petitioners are being paid the minimum pay scale. Okay,
Lordship.
when do you want?
Lordship, in 2 weeks, then lordship.
Why 2 weeks?
Lordship, because that notification will be if you get the notification, verify whether sunset clause is available or not, and whether the petitioners are entitled or not.
Please, after
Lordship.
2 weeks.
My lord, one copy of this notification may be served to me, my lord.
Yeah, the
Producer
will they will
file that for an
affidavit,
Lordship. Photo produce.
What is that? No, how many meters are there? This one. We take it up.
My lord, may I make a small prayer, my lord? Because item 12, man, I was late, my lord. That time I was a legal aid counsel, my lord, but presently I'm not a legal aid counsel. Whether I can be permissible to appear or not, that's the thing.
Oh, you're no more the legal aid counsel.
I'm no more a legal aid counsel, but everything was done by me in a to
Give me that item 8 file,
I don't 12,
item 12.
my lord. Otherwise, this is regarding, my lord, the removal from service, so I'm challenging the disproportionate service. Does the issue arise between his constable, battalion, some.
Where the panel of legal aid counsels?
Otherwise, your lordship permits, on 29th, my lord, it's fixed. I will just argue the matter, my lord. If any things,
Okay, okay.
I know,
Then I'll leave the order as it is.
my lord.
Okay,
I will just, on that, I will conclude this, my lord. It's a 2014 matter, my lord.
okay.
Last day also, I was little late in reaching, and today also, I just apologize for that.
Date is fixed.
29, my lord,
29.
29 2.
It was fixed.
Yes, my lord.
Okay.
29 February.
Okay, we'll see on 29th.
High level estimate.
Item 15 and 16.
We have the judgment. You have the
But
judgment.
perhaps we are not able to find a judgment, my lord. However, my lord, there are, after pursuant to the notification, we have passed another office order, my lord. Accordingly, we will verify, my lord.
Okay. Okay, just call us. I'll be back in 5 minutes.
My lord.
Yes. Resolution number?
93.
Hmm.
That is in page 48, my lord. Item 16, page 48.
Hmm? Item?
16, page 48.
Yes.
So, my lord, here, now as per the notification based before lordship, they have
Well, let
considered
us see
regarding our pay scale, etc. But there is no indication that payment will be paid to me direct. Our prayer is that my payment should be made to me, not to through other. That may be clarified.
Is this the order that I passed earlier? Were you there in the?
No,
Give
which
me-
order? No, court has passed what order. That we have
Give him this. Okay, the printout on it, you just let him see it and bring it back. That's the order, isn't it? See the operative portion? Last
Yes,
page.
sir. Regarding submission made by the Learned Standing Council, APTF, disposed of directly the petitioner to submit the document for verification. That is, we are ready to help. Before the concerned PTCL authorities within a period of 1 month from today. Thereafter, the authorities of PTCL shall consider the case of petitioner in terms of the office order dated 2/12/23 within a period of 2 months from the date of receipt of documents of the consideration.
That's all.
Well, regarding payment, headache to us.
That will come automatically, it's there.
A little observation if you not to keep that the events of payment, getting payment, salary, direct thing may also be considered. That now I am getting from other employee. Money will go to his account. He will give me. Yes, yes. After verification. Naturally, you will also enlighten the verification on part.
Hmm.
That's all. We are agreeable to your lordship judgment.
Where's the resolution 93?
Yes.
That's the page number
40.
Of item?
It's 16.
Yeah, read, who are getting direct payment from ABDCL.
They are somebody are getting. We are not getting it.
On that part of
We are also
whether they are
outsourced.
directly getting payment from the external or they getting for the contractors. We all verify that.
You also verify.
No, let them, after verification, they should pay us. That's what we want. That my year ought to add that line. The salary may be
The
paid directly.
verification, if it is found that they are being paid directly, then they will be.
We are
paid
not
direct-
getting directly.
Then you are not getting directly, then how can we?
No, it goes to the contractor. Contractor gives. And but those who join subsequent to us, they're getting the salary directly in their account. Nowadays, it is the principle throughout the country. Salary will go to the account.
Heard Mr. S.C. Biswas, Learned Counsel for the petitioners. Also heard Mr.
Bida.
P.
Bida.
Bidas, Learned Standing Counsel, ABDCL for the respondents. Both writ petitions are same?
Yes.
As both the writ petitions have common course of action and relief sought for are identical. They are being disposed of by this common order. Stop. Para. You are serving where?
Serving my Lonka subdivision. Lonka and Noga.
1 minute.
Item 50 at Dhing. Another was in Lonka.
The petitioners in WBC number 6365 of 2023 are outsourced meter readers oblique bill clerks under Ding Electrical Subdivision ABDCL within bracket CAR, correct?
Yes, yes.
Within bracket CAR, stop.
Under Nogao Electrical Circle 2.
And the petitioners in WBC 5649 of 2023
Under Lonka.
are outsourced meter readers oblique bill clerks under Lanka
And Nogao.
and Nagong
Electrical
electrical subdivisions ABDCL within bracket CAR. On a commission of rupees, full stop. All the petitioners are receiving commission at the rate of rupees 3 per bill and presently getting rupees 8 per bill, which are being paid through the bank account of
contractor
of the contractor concerned. Anyway, I'm just stating the facts.
I have given the annexure.
Of the concerned contractors. Huh?
Page
Stop.
34.
The Assam, what board is it? The
Power distribution method.
no, what board is this? The board meeting
Yes, board.
of the Assam State Assam Power Distribution Company Limited, which was held on 28th of June 1983, 2023 by a resolution number 93, resolved for fixation and increase of wages of outsourced workers in ABDCL who are getting direct payment from ABDCL and converting them to contractual workers under ABDCL and for productive use of the outsourced workers. Stop. Para. As the petitioners are not getting direct payment, correct?
Yes.
From the APTCL and are not being given the increased wages, they have filed a present petition. Is the prayer is the same?
Yes, in prayer you wrote.
Same prayer?
Same prayer, same. Directing the commanding the respondent FTCL petition benefit of resolved resolution 93 dated 28/6/23 and directing the respondent to make the arrangement for direct payment to the account and to grant any other relief.
With the following prayers in both the writ petitions. Page 14. A to A. Stop. Para. During the course of hearing, Mr. B. Das, Learned Standing Council ABCCL, has produced an office order dated 2/12/2023, issued by the Chief General Manager within bracket HRA ABDCL, and the office order is reflected here and below. A to A. What we can do, no? So we can type out from here. This judgment I'll keep it. Tapara. On the basis of the office order dated 2/12/2023, Learned Standing Council ABDCL submits that the respondents have complied with the resolution passed by the Board of Directors on and therefore the petitioners may be directed to submit their documents, submit the relevant documents before the ABDCL authorities, and after verification, their grievance would be resolved. Stop. Para. Recording the submission made by the Learned Standing Council ABDCL. This writ petition is disposed of. Both the writ petitions are disposed of. Directing the petitioners to submit their documents for verification before the concerned ABDCL authorities within a period of
1 month.
1 month from today. Stop. Thereafter, the authorities in the ABDCL shall consider the case of the petitioners in terms of the office order dated 2/12/2023, and also for direct payment to the petitioners.
Eligible.
If they are eligible within a period of 2 months from the date of receipt of the documents from the petitioners with the with the with the above observations and directions, district petition stands disposed of. The office order dated 2/12/2023 is placed on record. Paul, you can take up this. Mona Lisa has typed it, so you can just call out.